Welcome to the latest Evershed Sutherland Legal Insights podcast.
Welcome to this Evershed Sutherland podcast, where we'll be looking at what lies ahead in the real estate dispute resolution world. My name is Anna Bevan-Jones. I'm a professional support lawyer within the real estate dispute resolution team at Evershed Sutherland, and I'm joined today by Carly Fishwick, a senior associate in the Manchester real estate dispute resolution team here at Evershed Sutherland. We've joined up today to discuss some of the real estate and real estate disputes related developments which are on the horizon as we embark on a new year, 2026. 2025 was a busy year where it comes to real estate, with new law, significant court decisions, and of course reforms. And there are no signs that things are slowing down as we plunge into 2026. We've decided to focus today on just 10 or so developments. But before we dive in, a short plug for the recent edition of InFocus, our regular client briefing. The Winter 2025 edition was released at the end of 2025. It delves into significant legislative changes, recent court decisions, and offers practical insights for landlord, tenants, developers, and advisors. You can access a copy via our website or contact Carly, myself, or your usual contact at Evershed Sutherland's Real Estate Dispute Resolution team, and we'll be happy to pass on a copy. So we'll start with developments in the commercial landlord and tenant domain and the potential introduction of a ban on upwards-only rent reviews.
Most of you will have heard about a bill introduced to Parliament on the 10th of July last year, which contains provisions which, if passed, would introduce a ban on upwards-only rent review clauses. The stated aim of the ban contained in the English Devolution and Community Empowerment Bill is to create fairer leasing conditions for tenants and stimulate economic growth. Now, this was an unexpected development and hadn't been the subject of prior consultation. And unfortunately, we won't know precisely how the ban will look until the bill receives royal assent. Arguably, we won't even know whether the ban will be introduced until then. But as we understand it, the government is committed to introduce it, so we're looking at when rather than if. But what we do know is that, as things currently stand, the proposed ban looks to prevent upwards-only rent reviews in commercial leases where the revised rent is not known at the time the lease is granted. So that includes, for example, open market rent reviews. It will not apply to all leases, however. It will apply to any business tenancy as defined in the Landlord and Tenant Act 1954. Recent amendments to the bill have clarified that a tenant does not need to be in occupation of the premises for the ban to apply. This covers the concern that a tenant may not be in occupation itself where, for example, there's an underlease in place, or the tenant hasn't yet taken up occupation. And the amendments have also brought head leases or superior leases into the regime. The Act will not apply retrospectively, so it'll only apply to new or renewal leases of property in England and Wales granted after the bill comes into force. So these are forward-looking provisions only and won't impact existing leases. Recent amendments to the bill mean that the ban will also cover both put options and call options. I mentioned earlier that the ban will only affect upwards-only rent review provisions where the revised rent is not known at the time the lease is granted. So it won't affect stepped rent increases that have been agreed at the start of the lease, for instance. The intention is to amend effective rent review provisions so that they allow tenants to trigger rent reviews, even if the lease says that the landlord must trigger it. And this is intended to prevent landlords from avoiding rent reviews during times of rental decline. Could the ban result in shorter lease terms being granted, or fixed rental increases every 5 years in those longer leases? It's too early to say, but clearly this development could impact tenants, landlords and investors, so plenty will be keeping an eye on it. The bill has completed its passage through Commons currently and is now undergoing the scrutiny of the landlords. And having completed its first and second reading is now at the committee stage. It may be some time, though, before the bill becomes law.
Moving on to reform of the Landlord and Tenant Act 1954. It's been just over a year since the Law Commission published its consultation paper examining Part 2 of this Act. This Act was originally introduced to provide security of tenure to business tenants in England and Wales during a shortage of commercial property stock following the Second World War. The potential reform of this Act has been a topic of conversation for many years, and the Law Commission examination was intentionally wide in scope so that it could fully reflect on the current system to understand whether this met the needs of the current commercial leasehold property market in England and Wales. The first consultation paper stage closed in February 2025, and an interim statement issued by the Law Commission following its consideration of the responses received to that first consultation stage indicated that the Law Commission had provisionally concluded that the existing contracting out model is the correct model, that there should be no change to the tenancies which should be excluded from the protection of the Part 2 of the Act, and that the 6-month minimum term threshold for protection should be increased, possibly to 2 years. We're now waiting for the Law Commission to publish a second, and that will be a technical consultation paper based on the responses it received to that first stage consultation and the conclusion it reached on considering those responses. The Law Commission has confirmed that they expect to publish the second consultation paper in spring of this year. And this feels like a good opportunity for the Law Commission to consider all elements of the current framework for lease renewal. And that's from arguably the arduous process of contracting out of the security of tenure provisions of the Act to issues such as the substance of the grounds to oppose the renewal of the tenancy, and even to the terms of the new tenancies, of course, as well as interim rent. And I'm going to move away slightly from the 1954 Act and just using this opportunity to highlight a development affecting leases of commercial property north of the border in Scotland. Some of you might be aware that at present, Scottish commercial leases do not necessarily end at the end of the term expiry date, and that's because of a process known as tacit relocation. The landlord or the tenant must give notice to quit at least 40 days before the termination date, otherwise the lease will continue. And this can catch both sides unawares and lead to confusion and disputes about whether sufficient notice has been given, etc. The leases, automatic continuation, etc. Scotland Bill was intended to change this, and it was aimed to provide greater flexibility to parties to agree that their commercial leases will end on the expiry date and not automatically continue. And that would therefore simplify the process for landlords and tenants. The bills faced significant scrutiny during the consultation phase, ultimately leading to it being officially withdrawn in September last year. So we are keeping the status quo for now, but also keeping an eye out for any further potential reform in this area.
We're keeping with the commercial property theme for a little longer and draw your attention to an appeal in the London Trocadero 2015 LLP and Picture House Cinemas Limited and others 2025 High Court decision. Last year, the High Court found that the landlord claimant in that decision was not entitled to pass on insurance commission to its tenant as part of the insurance rent charged under the lease. This meant that Picture House was not liable to pay that portion of the charges which represented insurance commission. It was entitled to recover sums it had previously paid on the basis that Trocadero had been unjustly enriched. There's been widespread comment on the case since the decision was handed down, and its potential ramifications to the retail property market in England and Wales has been deemed significant. Responsible landlords engaging responsible brokers and insurance companies are, however, unlikely to be significantly impacted by this case, particularly given that the standard wording in the widely adopted model commercial lease permits the retention of the landlord of such commission. The case does, however, raise the prospect of tenants taking a more detailed look at their insurance rent payments. This decision will be of interest to landlords and tenants of commercial premises in England and Wales. Permission to appeal to the Court of Appeal was granted last year, and we've just heard that the appeal date has been fixed for 3rd of June 2026, so we'll be keeping an eye out for that decision. Moving on now to commercial service charges. The new RICS service charges code relating to commercial property, so that is the 2nd edition of the code, came into force recently on the 31st of December. As many of you know, the RICS code provides a best practice framework for managing, reporting and reconciling service charges across commercial and mixed-use buildings. So although the code cannot override lease terms, it does set out industry expectations and is used widely by professionals involved in the field. The main charges appear to be around deadlines for budgets and year-end accounts, clearer apportionment matrices, and for the mixed-use buildings, expanded rules to reflect the regime under the Building Safety Act 2022.
A short update now on the Terrorism Protection of Premises Act 2025. This act was passed in April of last year and aims to improve public safety by imposing a legal duty on those responsible for qualifying premises and events to implement measures that reduce the risk of harm during terrorist attacks. The act is also known as Martin's Law in tribute to Martin Hett, who was killed alongside 21 others in the 2017 Manchester Arena attack. What it means to be a qualifying premises or event largely comes down to the activity being held at the premises, whether the premises is open fully or partly to the public, and the number of individuals, and that includes staff, who can reasonably be expected to be present at the same time in connection with one or more of the uses specified in the Act. And the uses specified include, for example, shops, hotels, and use for the sale of food or drinks or bars and so on. The steps which might need to be taken to protect could include providing staff with protection from terrorism training, could include conducting risk assessments and considering what reasonable or reasonably practicable measures might be taken to reduce the risk. Responsible persons who fail to comply run the risk of facing regulatory inspections and substantial fines, but the bill also includes some criminal offences for non-compliance. We're expecting the Act to come into force around April 2027, so there isn't yet a legal requirement to comply. The government guidance refers interested persons to the free technical guidance and operational advice on protective security, and those can be found on the National Protective Security Authority and Protect UK websites. We've also already seen some guidance being produced by various institutions, such as the Department for Education, giving some insight on how the Act impacts their properties, and that's in efforts to ensure that those affected are using this time up to April 2027 to prepare. More should come from the government by way of guidance designed to assist those whose premises or events might be in scope to understand their new obligations. So we are keeping an eye out for those.
Moving on now to the Building Safety Act, which came into force more than 3 years ago. Most of this significant piece of legislation is now in force, but we are still awaiting regulations which will see the remaining few provisions take effect in England. The Building Safety Levy is due to be introduced this year. We're also starting to see how the Scottish Government is implementing the Building Safety Act in Scotland. And in Wales, the Building Safety Wales Bill was published last summer. And indications from the government since then is that it should be passed this year, and at least parts of it will be in force as early as 2027. We've also been following how the First Tier Tribunal, Upper Tribunal, and the Technology and Construction Court have been interpreting their powers under the Act. At the end of October last year, the Supreme Court granted permission to appeal, in part in relation to 2 significant decisions which consider the retrospective effect of the Building Safety Act. Those decisions are Triathlon Homes LLP and Stratford Village Development Partnership and others, and the Adriatic Land 5 Limited and long leaseholders at Hippersley Point cases. Permission to appeal to the Court of Appeal has also been granted in the Almacanter Centrepoint Nominee Limited and Devoke and others case in relation to the recovery of service charges relating to cladding remediation from leaseholders. There's no authority on this point currently, so this decision will be groundbreaking. The appeal is due to be heard by the 13th of October this year. We'll of course be following all of these decisions closely.
So plenty happening in the commercial property sector, but what about residential property? What's happening there? The Renters' Rights Act received royal assent in October 2025. This act aims to offer greater security and stability to renters and improve the standard of housing stock in England. Different regimes apply in Wales and Scotland. The timetable for implementation of the Act has been released, and that confirms that the Act will come into force in stages. This stage approach is meant to provide sufficient time for landlords and letting agents to prepare effectively towards the new regime. Now, some provisions of the Act came into force on the 27th of December 2025, but the move to a new system of periodic tenancies and new grounds of possession will come into force on the 1st of May of this year. I mentioned there new grounds of possession. From the 1st of May, there will be around double those currently in existence, double the grounds of possession, and some of the existing grounds will be varied from that same date. One update to note in particular is that notice periods which landlord need to give tenants will be longer, more notice requirements offering more security to tenants, of course. And once the relevant provisions are in force, Section 21 no-fault evictions will come to an end for new and existing tenancies. Just to note there, however, that there are some transitional provisions which apply where a Section 21 notice has been served before the 1st of May and that notice is still valid. Fixed term assured tenancies and assured short-hold tenancies will be abolished in May, and these will be replaced or converted to periodic tenancies, meaning that tenants would be able to stay in their houses until they decide to end the tenancy by giving 2 months' notice, or the landlord is able to make out one of the termination grounds. From May, also, the limits on rent that a landlord can ask for in advance and on in-tenancy rental increases will also kick in, as will changes that aim to bring to an end rental bidding. So landlords and agents will be prohibited from asking for or accepting offers above the advertised rent. Later this year, we expect other elements of the Act to come into force, for example, the launch of a new database and the establishment of a new ombudsman. And later still, we should expect developments which will clarify the legal expectations where it comes to addressing serious hazards within homes, and the private rented sector is to be subject to the Decent Home Standard. The government has released a guide to Renters' Rights Act, which should also assist those affected. And those affected will, of course, need to take some time now to understand how the Act affects them, make preparations for the new regime. We're still waiting for some details, of course, in the form of regulations, which are awaited, and we will also be looking at how the courts and tribunal manage the potential influx of cases resulting from the changes in this area of residential tenancy law.
Moving on now to look at leasehold and freehold reform. The Leasehold and Freehold Reform Act was passed in May 2024. The Act's intention was to give better rights to the millions of people who have long residential leases in England and Wales. The most notable provisions of the Act are as follows. New leasehold houses, but not flats, will be banned, save for in exceptional circumstances. As such, every purchaser of a new house in England and Wales will own the freehold of their home and will not, therefore, have to pay any ground rent. And the creation of longer, more accessible leases. Standard lease extensions will rise from 90 years for flats and 50 years for houses to 990 years each. Regulations passed since the introduction of the Act have brought into force the removal of the requirement for a new leaseholder to have owned their house or flat for 2 years before they can extend their lease or buy the freehold, and also the extension of rights to manage and enfranchisement. Leaseholders in mixed residential and commercial buildings previously couldn't buy their freehold or take over the management of their building where more than 25% of the floor space was non-residential. But now they will be able to do so if less than 50% of the floor space is non-residential. Some landlords were unhappy with this development and brought a judicial review claim, seeking declarations that certain parts of the Act were incompatible with Article 1 of the First Protocol of the European Convention on Human Rights. The High Court recently rejected that claim, and supporters of the Act are now keen to see the remaining provisions brought into force. Keeping on the theme of leasehold interests, and moving on to leasehold and common hold reform, in early 2025, the government published a common hold white paper, which promises to ban new leasehold flats by 2029 and make common hold the default tenure. This forms part of the government's commitment to providing leaseholders with greater rights, powers, and protections over their homes. For those who are not familiar with the term common hold, this is a form of freehold ownership where each individual owns their unit outright with no expiring term, unlike with leasehold tenure. With common hold, the Common Hold Association decides how to manage the property, and it is anticipated that owners of large residential blocks of flats will appoint a managing agent to deal with the day-to-day management of the building. The paper was on the common hold system in the context of residential blocks of flats, but it does refer to its potential wider use in other settings, such as commercial blocks or retail and industrial parks and shopping centres. The government has very recently confirmed that it is still committed to publishing the consultation on banning leasehold tenure for new flats and the draft Common Hold and Leasehold Reform Bill later this year. The aim is to work jointly with the Welsh Government also to ensure that the reforms apply across England and Wales.
And our final instalment in this session is the Law Commission's 14th programme of law reform. In September last year, the Law Commission published its 14th programme, announcing 10 new projects which it considers ripe for reform and that it intends to review over the next few years. The programme assesses emerging societal change challenges with a particular focus on efficiencies in property law. Of the 10 projects to be considered for reform, those most relevant to the property sector will be those that will look at agricultural tenancies, commercial leasehold deeds, management of housing estates and ownerless land. And when it comes to commercial leasehold, that project will focus on 2 sub-projects. The first sub-project would be focused on 2 aspects of the law relating to commercial leasehold transactions, being the Landlord and Tenants Covenant Act 1995 and the rights of first refusal under the Landlord and Tenants Act 1987, insofar that as that law relates to commercial premises. Potential reforms to the anti-avoidance measures in that 1995 Act, which applies in relation to former tenants and guarantees, are likely to be welcome as they could ease difficulties encountered in complex leasing transactions involving, in particular, intra-group assignments. The second sub-project will be a scoping project focusing on the law governing the maintenance, repair and upgrading of leased commercial businesses. So dilapidation claims and service charge claims could be affected. We don't have any timings for these projects, but expect we will hear more on at least some of them this year. The Law Commission is, of course, already considering a number of property-related projects, including the one looking at renewal of business tenancies under the 54 Act, which we mentioned earlier in this session. And that brings this podcast to an end. We hope you found it interesting. The Real Estate Dispute Resolution team have written briefings on most of the developments highlighted in this session. If you'd like to dive a little deeper into any of them, I've already mentioned that our latest edition of InFocus was also released at the end of last year and can be found on our website, or you can contact Carly, me, or your usual contact in the team for a copy. If you'd like to discuss any of the developments mentioned, please do get in touch
Thank
with
you
a
for
member
listening
of
to
the
the
Real
Evershed
Estate
Sutherland
Dispute
Legal
Resolution
Insights
team here
podcast.
at Evershed Sutherland. Thank you for listening.